Section 2. Good real estate practice in the Arizona market. Introduction, from key terms to real-world practice. In Section 1, we covered the key terms that create legal risk: fraud, misrepresentation, earnest money, clear title, cloud on title, fixtures, and legal limits. Now we move from vocabulary to daily practice. Good real estate practice is not just about closing deals. It is about protecting the public, protecting your client, protecting your broker, and protecting your license. In Arizona, many violations happen because an agent didn't mean to break a rule. But intent does not always save a licensee from discipline. The most common risk areas include advertising, earnest money, presentation of offers, disclosures, license renewal, representation, client advice, broker supervision, unlicensed activity, subdivisions, and property management. Advertising. The public sees it first. Advertising is often the first place the licensee creates risk. A social media post, flyer, sign, video, website, AI-generated image, or open house post can all be advertising. Under the updated ADRE rules, advertising remains a major compliance issue. R4-28-502 governs advertising by licensees, including electronic media, internet advertising, and modern marketing practices. The 2025 rulemaking specifically updated rules involving advertising, electronic media, AI, and renderings. The basic rule is simple. The public must be able to clearly tell who is advertising and which broker is responsible. Broker name must be clear. Every advertisement must clearly and prominently identify the employing broker's legal name or DBA as licensed with ADRE. For example, if an agent posts a listing on Instagram and only uses the agent's name or team name, that may be a problem. The broker's name must be included in a clear and prominent way. Owner-agent disclosure. If a licensee advertises their own property for sale, lease, or exchange, the advertisement must disclose the licensee's status as both owner and agent by using owner/agent. This is one of the easiest rules to follow and one of the easiest rules to violate. If you own it, say it. Advertising another broker's listing. If a licensee advertises a property that is listed under another person's real estate employment agreement, the listing broker must be displayed clearly and prominently. Example, an agent hosts or advertises an open house for another agent's listing. The advertising cannot make it appear that the property is the advertising agent's own listing or transaction history. Teams and groups. Team advertising must be handled carefully. A team or group name cannot replace the broker's name. The team name also cannot create the impression that the team is a separate brokerage. Best practice. Use the team name if allowed, but always include the employing broker's name clearly. No misleading advertising. Arizona law prohibits false or misleading advertising. A licensee must not misrepresent facts or create a misleading impression. Examples of risky advertising include calling land 1 acre when it is not 43,560 square feet, using AI or artist renderings without clearly disclosing that the image is not the actual property, advertising horse property without verifying zoning, HOA rules, deed restrictions, or county requirements, promoting a payment, interest rate, or price that is not actually available to all buyers without proper disclosure. A good rule is this: if the advertisement could cause a reasonable person to misunderstand the property, price, ownership, broker involvement, or condition, rewrite it. Signage requires written consent. Before placing a sign on a property, the licensee must have written consent from the property owner. The sign must also be removed promptly if the owner requests removal. This includes for sale, coming soon, open house, for lease, and similar signs. Earnest money, small deposit, big responsibility. Earnest money is one of the most common areas where agents create unnecessary risk. Under R4-28-803, the contract must state where earnest money or any down payment will be deposited, such as the title company, broker trust account, or other depository. Best practice: do not leave this blank, do not guess, and do not casually promise the buyer that earnest money will be refunded. Earnest money depends on the contract, timelines, contingencies, and facts. Presentation of offers. Arizona rules require offers to be presented promptly. R4-28-802 states that during the term of a listing agreement, a licensee must promptly submit all offers to the client unless the client has given proper written instruction or the contract provides otherwise. Example, a seller accepts an offer on Monday. On Tuesday, a better offer comes in before closing. The listing agent cannot ignore it just because the seller already accepted another offer, unless the seller has properly instructed the agent in writing not to submit additional offers. Disclosure and notification. Good practice requires disclosure of known material facts. If the agent knows something that could affect a party's decision, the agent should not hide it, minimize it, or hope someone else brings it up. Arizona case law supports this concept. In Hill versus Jones, the court emphasized the importance of disclosing known material facts that may affect a buyer's decision. In real estate practice, silence can become a problem when the licensee knows the fact matters. Advice to clients: stay in your lane. Agents may explain forms, timelines, and real estate procedures. Agents should not give legal, tax, title, lending, engineering, construction, or environmental advice unless properly licensed in that field. That issue is outside my area of expertise. I recommend you speak with the appropriate professional before moving forward. Broker supervision. The updated ADRE rulemaking also clarified broker supervision and professional conduct rules, including R428-1101, R428-1102, and R428-1103. Designated brokers are responsible for supervising licensees, advertising, documents, and brokerage activity. Agents should remember that poor documentation does not just create risk for the agent, it creates risk for the broker and brokerage. Closing thought: good real estate practice in Arizona comes down to this: advertise clearly, disclose honestly, document carefully, present offers promptly, handle earnest money correctly, and stay within your license. If Section 1 taught us the vocabulary of risk, Section 2 teaches us where that risk shows up in real life. Online discussion question 1. Why is advertising one of the most common areas for real estate violations? Answer: because advertising happens quickly through signs, flyers, websites, social media, videos, and electronic media. If the broker name, owner-agent disclosure, listing broker, or property facts are missing or misleading, the licensee may violate ADRE rules. Question 2. Why should an agent avoid promising that earnest money will be refunded? Answer: because earnest money depends on the contract, contingencies, timelines, and facts. A licensee should explain the process, but avoid making guarantees. Question 3. What should a licensee do when asked for legal, tax, title, or construction advice? Answer: the licensee should stay within their area of expertise and recommend that the client speak with the appropriate professional.